Hey, Brian Parker here, coming at you with a good one today. I do a lot of videos where I tell you how to do something, I give you templates, and I want to go just another step deeper on that. This is filing an answer to a creditor lawsuit. We're using Cap 1, but here let's put up what a Cap 1 caption looks like. Shazam. And so when you get a lawsuit come in, you got to look at the caption. And now when you create your lawsuit, you have to add your name and information to the lawsuit answer or responsive pleadings. So then it would look like this, Shazam. And I've got David Debtor there. You'd have David Debtor as your name. You'd say what it is, which is defendant answer to Plaintiff Capital 1 and Exhibit 1 and 2. Exhibit 1 and 2 is usually Exhibit 1 is always the counter affidavit, don't forget about that. And also, I add the lawsuit that I say is all screwed up. That's a matter of form. You can do that if you want. If there's other things you want to add, you can add those things. And then at the bottom, you'll say the attorneys that are representing the plaintiff, say attorneys for plaintiff, and then you'll have your name, your address, your phone, your email. Most states require you do it that way. As a matter of form, you want to be communicated with by the court if anything happens, also by the other side. So it just makes sense that you give them contact information. That's how captions are set up. You can see at the top, you put the state you're in and the district you're in. And that's pretty much how you set up your caption. I, as a matter of my form, will add a preliminary statement and a little blurb for the court to immediately pick it up and go, oh, so this is what the defense is about. I cannot stand sterile, non-committed answers. Most courtrooms, most states allow you to go, except, I neither admit or deny or admit. I don't think you do yourself any favor doing that. There are services out there that give you the bare sterile minimum, and in some cases miss what the law requires you of that state to do. I don't do that. I want right up front the court to know exactly what I'm talking about. So here, let me just put up the part that I'm talking about. Defend a preliminary statement as to no stated claim. Right, first sentence, that's it. Denied as to account stated and unjust enrichment. In this case, there are 3 counts. It's a breach of contract, account statement, and unjust enrichment. And those are the 3 counts of most collection lawsuits. And I say I deny them all. I say why. I say they're not the owner of the debt. That's my theory of my case. And then in this case, this one's in Michigan, I add a statute which I think applies. And then I have my preliminary statement. Let's put that up there, Shazam. And that's me breaking down why I say they're violating and what they're violating. Again, you look for your state law, the FDCPA, if you think it applies, and your state collection law apply. And then I break down, in this case, why I think Capone, C-A-P-O-N-E, you think about what that means, is in the wrong and is not the right to bring the case against my clients. And I highlighted there's no proof of Capone having standing to sue defendant in their lawsuit. There's no proof Capone properly repurchased or reassuming the account receivable debt. In securitization, they move the debt over to the trust, but there's a default mechanism in most pooling and service agreements that's saying they must send it back to collect the lawsuit. If there's no proof of that, how do you know that the securitization has only gone one way and hasn't come back the other way? They've got to provide proof of that. Again, we've talked about the fact that they claim they're suing as a debt when they are only using the word account. See all my videos. In this case, I also said I've looked at the contract they attach. So they attached a contract that was not my client's. They're just doing a facsimile or a copy of some contract. But I go in on that and I say, the law that applies to your agreement says specifically right in their contract, it says Virginia, and you can see Shazam, that is up there. And again, that's Exhibit 2, as I said, that's part of their complaint. And you want the court to go to Exhibit 2 attached to your answer rather than having the court go through all the paperwork in the file. You got to make it easy for the court to take it easy on you. So then we come in and we say there's no contract between the parties. Here's the statute they're violating, and Virginia law should apply. They've used, in this case, Michigan. So you have to answer. When you answer a lawsuit, and this is a common question from folks, each lawsuit has from maybe 4 to maybe 30 paragraphs, right? This one will have 22, but don't be, oh my God, there's 22. I'm going to show you how to do an easy way to answer this stuff. So you have to answer per paragraph. Technically, if you miss a paragraph, you've admitted it, or you've made it easier for them to prove because you didn't deny. So I'm going to show you, take each paragraph and answer each paragraph. A lot of the work that you're about to do in this particular video explanation has already been done for you when you create the counter affidavit. You've seen gobs of my videos saying counter affidavit, counter affidavit. It is all about the counter affidavit. So the counter affidavit will be accumulated by you when you rip apart their lawsuit and figure out what their deficits are. See all my videos. Let's do that 1 to 5 series on breaking down the complaint. I think I called it analysis of a lawsuit. You can see that. That's a good start. I've got PDF free cheat sheets, how to answer, how to create a counter affidavit. See those. You can fill up the screen. How to answer a Cap 1 case. How to answer Midland Credit. How to answer UHG. How to answer Bank of America. How to answer American Express. I'm trying to fill it all up. Hello? Anyway, so I've got all the answers. This is breaking it down, as I said, paragraph by paragraph. So here's paragraph 1 of their lawsuit. Now it's a simple thing. Pursuant to 2.113C2, there's no other pending or resolved civil action arising out of these transactions or occurrences alleged in this complaint. Each state has its own rules, but you can't keep filing the same lawsuit. And you've got to say something to the effect, well, I haven't done this before. Well, don't just assume anything. I looked up the rule. And here is how I answered number 1. So first, let me put number 1 up there for you. Shazam. And that's them saying pursuant to 2.113C2, yada, yada, yada. So here's how I answer. First, I put up answer an affirmative defense, the title. And then I say, wherefore. You always start wherefore. I've done it for you. And then in response, I deny. Why? I went and looked up the statute. Turns out they were wrong. 2.113C2 states, an attachment or reference to an attachment under C1 or B is part of the pleading for all purposes. That doesn't apply in the context. They're saying there's no other pending cases. That rule doesn't apply. So I point that out to the court. You've got to point out everything as to their deficits. So let's put up number 2, 3, and 4, Shazam. And that's 2, 3, and 4. So let's do number 2, answer. The answer to paragraph 2, Shazam. And as we said before, the law that applies to your agreement doesn't apply to this case. So you put it in number 2, denied. Number 3 is, upon information and belief, defendant is domiciled in the city of Kalamazoo. Okay, I put up, neither admit or deny it, because defendant should not be sued in this case or court in the state of Michigan. Look at the plaintiff's contract. Number 4, here's the answer number 4. Neither admit or deny. Defendant should not be sued in this case or court. See their own document. So now they're going to get into their argument against you. So first, count 1. Remember we said that, what was a fly? A breach of contract, Shazam. The plaintiff incorporates by reference paragraph 1 and 5. So you just say denied, because you don't admit to anything, right? Unless it's true, and half that stuff I just told you is debatable or admit or denied. So I just put denied. Number 5, denied. And then number 6, we talked about in many videos. See at least 2 videos on the linchpin of the videos. Linchpin. See my dirty socks video. That's a great one. with everything you could possibly want in a debt by a lawsuit. See my dirty socks video, circling all around, and whoosh. Okay, so number 6, that on, just put up number 6, that on January 6, 2022, defendant entered into a contract with plaintiff for good. So in a breach of contract action that they're alleging here, you say there's a contract, there are duties, defendant breached his duty, here's the damages that occurred. So if they've added the contract, that's a big thing for them. But they added a contract that was a copy of a contract. We don't know if those terms or conditions apply to you, but we do know that contract that they attached says you got to be in Virginia, not in Michigan. So here's what we put for number 6, Shazam. And we're saying we denied as to the lack of any contract, payment, assignment with the plaintiff, and the Capital One Trust comment. So, and we put a couple of cases. In my last video, I gave you a list of cases, and you can use those from your state, whatever your state is, but look up your assignment cases or breach of contract cases. And here's their number 7, Shazam, that a copy of the contract is attached, or alternately the contract's in the possession of the defendant. That's a matter of form. In Michigan, if you don't attach the contract to a breach of contract action, you lose, plaintiff. So they say, here it is, but if not, it's in your possession. And so you look at the contract and it ain't there. It's telling you to go to Virginia, but it isn't your contract and there's no proof it is. So you deny at number 7, put up number 7 answer. Denied as the contract attached to the lawsuit states the case should be in Virginia and there's no proof of an account stated claim. We're going to get to that. We're foreshadowing where we're going. Put up number 8, that the contract was entered into for valid consideration and lawful for proper purposes and is legally enforceable. Here's my 8 response. Shazam. Denied as this plaintiff have any interest in the account. Shouldn't be in Michigan. Wrong contract attached. Number 9, plaintiff did everything right. We performed all the obligations and the terms of the contract. Here's my response, number 9. Denied as there's no proof of plaintiffs conforming to the contract or terms and condition. Essentially, they didn't add a contract. They claimed that that we've breached. And by the way, they breached the contract themselves by filing it in Michigan, when their own contract that they attach says Virginia. These are all things you point out to the court. You got it, you point it out. Let's put up the number 10, Shazam. Defendant has without excuse defaulted and materially breached the contract. What contract? The one they attach says being Virginia. I don't know what breach of contract law is in Virginia, but it ain't here right now. So number 10 response. Defendant denies and further there's a breach and default by plaintiff in bringing the case in Michigan. So under the contract or terms and conditions between the parties attached, that is not the contract between the parties. You got to say it, right? Don't just go admit, deny, not sure, because stuff could be held against you without explanation. By the way, that's the safety of saying admit or deny. You're not held accountable. But you're also losing the interest of the judge who says, okay, I don't see any reason why you don't know this. Or the other side, if they see you doing a deep dive into these answers, and this is why I preach, especially the securitization stuff, you want to set this up for settlement of a creditor case, which is already hard to do. So you show detailed responses. The other attorney's no dummy in that respect. He's like, I don't need this hassle from an educated consumer. That's going to work towards a settlement. So number 11, here's put up there number 11, that as a result of the breach. Remember I said, show there's a contract, show the guy breach, show the damages as a result of the breach of the terms and conditions. That's why they break it down like that. And they say, plaintiff expressly disclaims any all attorney fee. There's a reason why they do that. We won't get into that right now. But your number 11 response is Shazam. You deny there's no account or debt between the parties without any proof of the true owners of the debt, and how does plaintiff have an interest in this case with a false contract attached. Now I'm going to show you how to speed this up. You put your wherefore clause, obviously that's up there. request that this court deny the relief requested in plaintiff's complaint. You put up what you want. Wherefore is the beginning of what I want. So here is their count 2 account stated all the way to 17. Shazam. And next to it, I'm going to put their count 3, the unjust enrichment. Shazam. And your response won't be going down. You do every response per paragraph, but you've already done the work. So what you do is, look at number 12. Let me put up 12 through 17. Shazam. And that's denied, obviously, see Exhibit 1. Number 13, denied and further denied as to pleading 8 to 11. You've got already done, so you just say, look at 8 through 11. And 14, look at 8 through 11. 15, denied and further, look at 8 through 11. 16, denied. I've got all the animals here now. Guys, come on. So 16, denied 8 through 11. And then you go to your unjust enrichment claim. Put that up, 18 through 22, Shazam. And you can see 18 is denied, see Exhibit 1. 18 through 22 is denied under the theory without ownership assignment proof or secured trust involvement. This is, I deny, based on what we've talked about above. So that first breach of contract 1 through 11 will do all the work for you. 12 through 22. It's okay in most states, check your rules, to say I deny, and why? See 8 through 11. That reinforces 8 through 11 and it cuts your time down answering the lawsuit. Here's our wherefore clause, Shazam. Again, we're denying the relief plaintiff seeks and we're saying here's an affidavit, counter affidavit. You always want to refer whatever it is you're claiming. You got to have backing. That's the bugaboo of most collection lawsuits is they don't prove what they're alleging. We do, okay? So now we have what's a special form of pleadings that you have to do or lose it, and that's the affirmative defenses. Shazam. Let me put up 1 through 9, and those are really reiterating our responses to the lawsuit, how and why. For example, number 4, plaintiff fails to produce a signed agreement by defendant proving the obligations between Cap 1 and defendant, and that it's in a secured trust. Number 5, plaintiff's violating 2.113 in its pleadings. Remember we talked about how they claimed 113C2 applied and it didn't? Say it in your affirmative defenses. It's another form of responsive pleadings that if you don't bring it, you lose it. Did you bring your, suddenly the evidence comes out that you've got a great defense after doing discovery. You didn't plead it. Now you got to go to court and go, can I amend? Bring it if you suspect it or you have the proof that you have a right to that affirmative defense. So let's go 10 through 15, Shazam. And I've just cited in my affirmative defenses cases. I'm incorporating what those cases mean in defense. I say plaintiff number 13 violates 8036, which is your business records exception, talking about the false contract they attached. And then I make sure that I say, regarding that false contract number 15, it's got a law that applies to Virginia. So it's a whole plate of screw-ups that they've made that you want to bring the court aware of. Now, all that great work you just did means nothing if nobody's eyes see it. You have to do, let me put this up for you, the certificate of service, Shazam. You've got to do what's called a proof of service. Once you're in this game, once you're in the lawsuit, no matter what you do with the court the other side, proof of service to the court, proof of service to all the parties. It will save you, but it's also the law. You have to have a proof of service. So if someone says, hey, you didn't serve that to me. Oh, yes, I did. Here's the proof of service, blah, blah, blah. So I will attach to this video at KillDebt.com the template for an answer, a counter affidavit template for this answer for Cap 1, and I will attach their lawsuit for you to see where I got this from and how I did it. I'll also attach my show notes. But this is a quick insight into how to file a creditor, a response to a creditor lawsuit. We use the Cap 1 case. I hope it is helpful further breaking down how to answer these things. And don't just do admit, deny, I don't know. If you say it, if you bring it, support it. The court will love it. The other side will, yeah, we better get rid of this guy. When you present a good defense, it's offensive to the other side because they're like, oh, this isn't your regular unrepresented. They pray, like I was talking to a lady today very quickly, and they're just giving her all sorts of problems. And I know the attorney that's doing it. She's not represented by counsel and she wants me to help her. And she goes, well, they said they can't do this and do this. And my response is, yeah, but now I'm going to ask for that. And we're going to get it for her. We're going to take care of her. And it's unfortunate. But because you are not represented by an attorney, you can be represented by power, education, and a response beyond I admit or I deny. Because when the attorney sees that, he knows he's dealing with more than just a regular Joe or Joanne. He's going to have to get rid of this person. They do not like educated consumer. So try to do your best and be that educated consumer and be a problem parker. Thanks. Bye.